Welcome to the People's Law School, an effort by the Alabama Association for Justice to educate you as to our court system. Tonight, it is our special pleasure to bring Judge Sybil Cleveland here to you by special request. Several people over the last couple of years have asked me if she could speak, and so I saw her the other day and she said she could take her time to walk down here. Since this, although this is the courtroom of Judge Rodenhauser, hers is the next courtroom. So she feels just as at home here as there. She graduated from UNA. She graduated from the Cumberland School of Law. And there is a curriculum vitae, which you will receive next week, wherein you will see that she is a member of many organizations in our community and is quite a leader in our community. But the best thing I can say about her is that she has earned the respect of all of the lawyers here since she has been a judge in this courtroom since 1999. So that even when she rules against me, I understand why. I understand there was a reason for it, and I say, yes, ma'am, I understand, even if I didn't at the time. But it is my pleasure to present Judge Sybil Cleveland. Thank you.
Brinkley. Well, first of all, I want to say it is a pleasure to be here and to address you all on the issues as it relates to the court system. I also want to commend you all on taking the time out of your schedules to come in and try to engage and find out what is going on in the court system, how it operates. I looked at your schedule, and you all have certainly heard from some very esteemed colleagues that are very knowledgeable in their areas. I hope not to disappoint. As Mr. Brinkley has stated, I am a municipal court judge. I've been on the bench now since 1999, and I will add that has been the majority of my career since coming out of law school. I took the bar in 1991, and I practiced in Birmingham. And I was a assistant prosecutor in Birmingham in their municipal court. I simultaneously practiced law as a defense lawyer, and I did that for about a year, and then I got hired to come here. This is home somewhat for me, North Alabama. And I got hired to come here, and I was in the DA's office for about 6.5 years before my appointment to the bench. I am an appointed judge. I'm appointed by the Huntsville City Council. I'm proud to say that I am currently in my fourth four-year term. And I hope that me, along with our staff, I hope that we are delivering the type of service and expending justice in a way that's fair, that people respect, and they know that they can count on whenever they come through the doors of this building. I wanted to talk a little bit about the role of municipal courts in the judicial system. I'm not really sure how much you all know about the system in general. I did see on your schedule where you have heard from Judge Mann on the court system in general. You've also heard from Attorney Phil Price on DUI law. But I want to talk to you all just generally about the important role that municipal courts play in the judicial system. Now, regardless of whether you're talking about a small court, a small municipal court, say in New Hope, or perhaps some of the other smaller jurisdictions, or you're talking about a court like this court, the municipal courts play a very significant role. I think the headline-grabbing crimes are murder, rape, robbery, burglary. Those tend to get people's attention, right? You don't normally hear as much unless you hear it from maybe a family member or hear it from, a friend or a colleague at work about the troubles that people have when they come into municipal court, because we really and truly do hear from people from all walks of life. Anyone can find themselves in our presence here. In fact, I would venture to say, and Mr. Brinkley and some of the other attorneys would say that 9 times out of 10, when someone comes into contact with the criminal justice system, they're going to be in municipal court. And no matter how large the problem is or how small the problem is, if it's your problem, you want somebody to take that seriously, right? So just, in general, I want to tell you a little bit about the types of cases that we handle. Now, some of the common cases that you have probably heard about are cases like DUIs. We handle those here, domestic violence, physical violence, your theft, your property crimes, your misdemeanor drug cases. Those are some of the more common cases, but there are some other types of cases that we handle here that a lot of people may not realize that we handle, and since I don't handle them a lot, I had to write those down. But we handle arson second degree, we handle stalking second degree, criminal surveillance, criminal eavesdropping. We also handle promoting prison contraband cases from the jail. Now, granted, a lot of times with those cases, the misdemeanor cases usually involve cigarettes or lighters or things of that nature, but if you're talking about the passing of drugs and things of that nature, those are felonies, and those go to the county. We also handle soliciting prostitution type cases, and in my domestic violence court, I handle protection order violations. So these are just kind of typically the kinds of things that you'll hear, and of course, yes, we handle our share of traffic cases, but we are a high volume court, and you all have been coming here for several weeks now, and I know you have passed through the doors, and I'm sure you're impressed with this fabulous facility. But you all, we are truly proud of the City of Huntsville's Municipal Court, and the administration with the city. I would say they have done very well with the resources to fully stock this particular court with everything it needs to give our citizens justice in a way that justice ought to be given. I want to tell you a little bit about the breakdown of our court, and I do not know the composition in this room, but are most of you all from Huntsville, Madison County area? You can just shake your heads. Okay. Well, I want to tell you a little bit about this court, okay, and how it is comprised. There are 2 full-time judges. Judge Sonny Rodenheiser, this is his courtroom. He is our presiding judge. And Judge Rodenheiser's duties, in addition to his everyday docket, he is also responsible for the overall administration of court business here. And there is a lot of court business here. Okay, and I am second chair, full-time judge, and I also am available to Judge Rodenheiser on any given occasion to assist with any administrative matters that he might request that I become involved in. We also have a part-time judge, Judge Scott Rogers. We could not do our daytime court without Judge Rogers. Judge Rogers handles the majority of our traffic offenses in our night courts on Tuesday and Thursday nights, and we're talking about hundreds of traffic cases. Now, with Judge Rogers doing his job, it frees Judge Rodenheiser and myself up to dedicate our time to handle our misdemeanor caseload. Now, our misdemeanor caseload is high. The last time that I was given a stat, I want to say that we are handling about 80% of what Huntsville Police Department does every day. Not rape, robbery, and all of that. Some of that those misdemeanors that I told you about. That is what is filtered through this court. Now, the judges can't do it alone, okay? We don't do it alone. But I want to tell you a little bit about our staff and who we have to back us. We have a full-time magistrate's office that is staffed with 1 chief magistrate, supervising magistrate, and 7 magistrates. Now, magistrates, they screen every case, including traffic tickets that come through our court before they ever come into the courtrooms. Our magistrates screen those cases for probable cause to make sure that there is a criminal charge, okay? And they also conduct initial appearances and they set bonds. There is absolutely no reason for someone to get arrested and have to wait beyond that statutory period to see a magistrate and have a bond set. But that is a priority that this court has had since I have been here. It probably took place long before I got here, but that's something I'm very proud of. We also have a fully functioning probation office right across the hallway. That is rare in municipal courts. A lot of municipal courts have to contract their probation work, not us. We have 5 full-time probation officers that are also certified court referral officers, and as a court referral officer, they are certified in alcohol and drug-related offenses, and they have to be certified by the state of Alabama. That is a very grueling, long-term process to become certified, but all of our probation officers are certified. In addition to that, we have a drug lab. We are one of probably only a couple of municipal courts in the whole state to have its own on-site drug lab. And that drug lab, I'm telling you, with the drug culture, the way that it is now, crime is running rampant and is driven a lot by drugs and alcohol. So one of the best investments that the city of Huntsville has made in our court system recently is the investment in a full-time drug lab. And I'm going to tell you, our drug lab is staffed. It's fully staffed. We have a full-time drug lab technician. Our drug screening takes place Monday through Sunday. So if someone is on color code, the court is literally in their life every single day because they have to call in every day to see if their color is up. And if it is, they have to come in and they have to give a sample. So the court is literally, when you go on papers with the court system here, we are literally in your life every single day, and we explain that to them. So that is something that I am extremely proud of that we have. And I really need that resource. And one of the reasons I need it is because courts are having to work smarter these days. I know you all have heard about the state budget cuts and the court system cuts. Well, we're having to work a lot smarter too, because you can't lock everybody up. That's not always the answer. And one of the things that I feel in municipal court is an opportunity to make a difference in somebody's life. The people that we deal with primarily are people that still have hope. They still have hope in their lives. They have not become institutionalized because they've been a product of the Department of Corrections for a long time. A lot of these they're going to be your children. They could be your grandchildren. They could be a friend's child, or they could be you. And we have learned that putting people in jail is not the right answer for everybody. So we have what we call a lot of specialty programs in specialty courts. One of our most recent programs that we started by Judge Rodenheiser, we recently organized our pretrial intervention program for first-time offenders. And just about every single misdemeanor that is committed, if it's a first-time offense, almost, I say almost because all are not included, there are some exceptions, but the majority of our misdemeanors, if someone commits a misdemeanor in the city of Huntsville on a first-time basis, they are usually extended that opportunity to participate in pretrial intervention diversion. And that is fantastic because what they get is just golden. They get an opportunity to participate in a program that's tailored, that's suited, based upon the reason that they're here. And if they finish the program, they get their cases dismissed. And we usually put that magic language that's required, which is with prejudice, so that that person can then go and see an attorney and have their record expunged. I mean, it may sound like that's something small. It's not anything small. If you are trying to become licensed to be a lawyer, if you're trying to be licensed to become a teacher, and you've got this marijuana showing up on your background, even an arrest, you know, any kind of blemish when you're competing in a world where there's so much competition, I mean, you don't want anything on your record. So I am so glad that we finally started this program so that we're able to help people to kind of redirect them and get them back in, in that path that they need to be going without having to worry about those consequences. We also started in '04. I am just so proud of this program. We started a mental health court program. And I want to tell you, we started taking case referrals in 2004. That program has grown. It has made such a significant difference in the lives of people in Huntsville, Madison County. I conduct that program every other Friday, and the way that it operates is the mental health program functions to allow people to address their mental health issues. The actual prosecution of their cases are set aside, and they're able to concentrate on those kinds of issues that brought them into the system. Their mental health issues, a lot of times they're not compliant. And when they're not compliant, they get off their medications, or the medications become issues, or they need adjustments in those medications. A lot of times people tend to commit criminal acts. So we have an answer for that now. And when people come into the mental health court program, it is not a walk in the park. It is a very extensive program. I have a team that assists me with that every other Friday. And even when I'm not seeing the people for their status checks, there's still work being done. I have probation staff that is monitoring them. Some may be in a rehabilitation center in California. But if they mess up in California, tomorrow when I take the bench, I'm going to know about it, because we have that lifeline and that connection with them. But it's that accountability. And I think we've had, I don't know how many graduations since we started that program in '04, but it is something to see. We have it every other Friday. If you ever want to come down and watch, it is really something to see. It also functions as a drug court. It also functions as a veterans court. We have several veterans in there, and they are some of our top scholars. We're just waiting for somebody to listen to them, or somebody to care, or to, they have served our country, and they're just there, and they are encouraging to others, but they're so glad to have somebody that understood, hey, this is what was going on with me, and this is how I got into this, but I'm so glad that I've got somebody here that understands that will just encourage me. So that's what we do with that program. We also have, Judge Rodenheiser conducts an environmental court. He does that on Wednesdays. That's something that he has been doing for quite a while. And so when you look around and you see the beauty of our city, a lot of that has to do with what takes place in that environmental court. Some of the types of cases that you might see in that particular forum is community development, your animal control, your illegal dumping, things of that nature, things that keep our community safe and healthy. So I just kind of wanted to tell you all a little bit about municipal court and let you know that, yes, municipal court, we do handle a lot of tickets. It's a part of it. But we are a major part of the system, and I'm so happy that we understand that the people on our staff understand that, and it is our goal to try to make a difference, to try to intervene, to try to take that hope and turn it around into prosperity. And so that's all I have to say, and I want to see if you all have any questions for me. Yes. Oh, thank you. Thank you. Thank you all so much.
Can I ask
Oh, I think so. Yes.
Is the Crime Stoppers program in any way connected with your court?
No, that is a separate, that's a law enforcement tool. This is, okay, she said it's the Crime Stoppers program associated with the court system. And my answer to that is that Crime Stoppers is considered to be a part of a law enforcement tool. And remember, law enforcement is executive branch of government. This is judicial branch of government. Any more questions? Yes, sir.
Are the magistrates that review the cases licensed attorneys?
No, sir, they are not. I do know and understand. He asked if I got to remember to do that, if our magistrates are licensed attorneys. No, sir, they are not licensed attorneys, but they are experienced in the law in some shape, form, or fashion. Some are former police officers. Usually they have spent some time in our system somewhere, even if not in this jurisdiction. They have some type of a legal background.
Thank you, Judge Cleveland.
Thank you all so much.
So much for being here. As you can see, our legal system in the municipal court is in good shape here in the city of Huntsville. Judge Cleveland and Judge Rodenhauser do an extraordinary job. Our next speaker is Mike Wisner. Mike Wisner is a tax lawyer. He grew up right here in Huntsville, went to Huntsville High School, went on to the University of Alabama, where he got his degree in banking and finance, went on to the Cumberland University, where he graduated with his law degrees, cum laude, and then on to New York University, where he got his LLM and tax degree, and has practiced law a little bit in Dothan. He's a member of the Florida Bar, but has spent most of the last quarter of a century here in Huntsville practicing tax law. Since I've been around here for the last 40 years, what I've noticed is that most of the lawyers who got tax degrees don't really practice tax law. They practice securities or other things, but Mike Wisner is one of the few that he's been a tax lawyer, he is a tax lawyer, and he's one of the best in the nation. It is my pleasure to present to all of you one of Huntsville's own and one of the very best, Mike Wisner.
I did pull something off the internet here just the other day, and I thought it was kind of interesting, and it's the 13 top reasons for audit, and I'd like to go through it real quickly, but some of these I don't think I agree with, but let me just go through them real quickly, because a lot of people do ask, you know, how do we get audited? I have people ask me all the time when they have an audit, how did this happen? One way is failure to report income to the IRS. You get several 1099s, maybe you have a W-2, and you forget one of your 1099s. And if you do that, of course, the IRS is going to pick it up, because the 1099s go into the IRS and go into their computer, and as soon as you don't report that, your return gets kicked out. Large charitable deductions. I don't see that much, but I suppose if they were really large, my clients don't make really large charitable deductions. They make good charitable deductions, but I haven't really seen a lot of audit being come up as a result of charitable deductions. Claiming day trading losses on a Schedule C. Now this one's kind of interesting, because there's a fairly well-known lawyer in Birmingham. He doesn't practice law anymore, but he was a plaintiff's lawyer like Alan. He made in his lifetime millions and millions and millions and millions of dollars. I'm not kidding you. Probably the most successful plaintiff's lawyer in the state. Well, one day about 10 years ago, he decided he's going to quit practicing law and start day trading his stock. And he managed to lose about $4 or $5 million in a year day trading stocks. So he decided that he was going to take an ordinary loss on those day trades, not capital loss, because a capital loss can only be used against capital gain. And if you don't have capital gain, you don't get to use your capital loss. And it went to tax court, and I saw this the other day when I was looking through some cases for another client of mine. I came across his case, and he actually prevailed, and he was able to convince the tax court that even though he had been a lawyer, in the year he took these deductions, that he was in the business of trading stock. The loss was ordinary, and he got to take, and the purpose of it being ordinary from his point of view was he was able to carry it back as an operating loss and carry it to 3 prior years and get a refund on the prior years when he was making a lot of money as an attorney. Interesting case. Deducting business meals, travel, and entertainment. You know, I see that some, not a whole lot. Claiming 100% business use of a vehicle. A lot of people do that. It'll get you audited every time. You got a business, even if it's a business that takes a lot of your time in an automobile, unless you leave that vehicle at the business and drive a different vehicle back and forth from home to work, you don't get 100% deduction on your automobile. So that causes audits from time to time. Writing off as a hobby as a business loss. You see this a lot of times. I'm not picking on the doctors, but sometimes the doctors will go, and sometimes the lawyers too, go out and buy them a farm. They'll buy a few cows, and some tax advisor will say, you know, you could probably take a write-off and claim this as a business. So they start doing that, and they never make any money, and year after year they have heavy write-offs, and after about 3 or 4 years, the IRS's computer is going to kick you out, and they're going to come and examine you, and they're going to disallow the losses and disallow the hobby as a business, and they'll go back for the open years being generally the three prior years. Claiming a home office deduction. That's a biggie. You know, you claim that home office deduction, and the IRS is going to come and look at it, There's some very strict rules you have to comply with in order to be entitled to home office deduction, and frankly, most people that take the home office deduction aren't entitled to it. Alimony deduction, I don't see that. You know, if you take an alimony deduction and your ex-spouse is not taking the money into income, yeah, somebody's going to get a visit from the IRS because they'll match the Social Security's numbers up. But just taking a deduction for alimony paid is not going to get you audited. Running a small business, I don't think there's anything inherently suspicious with the IRS about running a small business, but small businesses, I would say, tend to have reporting problems simply due to lack of expertise and so forth. Failure to report a foreign account, I've never seen that ever. You know, nowadays on your return, when you sign it, there's a little box that gets checked that says you don't have a foreign bank account. I've never seen anybody audited for a foreign bank account. But, you know, if I was practicing in New York City or Miami or LA, maybe we would come across that some. Not so much here. Currency transactions, I've never seen an audit that resulted from a currency transaction. And then taking a higher than average deductions. Actually, I think most audits that come about as a result of something on your return is because there's some deduction on that return that's out of line with your income level. The IRS has a computer that says, okay, if you make this amount of money, then your deductions for the various things you can take deductions for should be within certain ranges. And if it's outside of that range, somebody's going to look at it. They might look at it and say, okay, it looks all right, we're okay with it. Or they may say, no, we need to have an inquiry. So those are the things that cause an audit. Some of them I don't agree with quite as much, but like I said, I just pulled this offline, and people often ask me, how do we get picked for exams? That is one way. There's also what's called the special audit program, and that is, I refer to it as a special audit program. It's basically where the IRS sits down and they analyze industries and they decide, well, we've got some abuses over here or some abuses over here, and they will focus on that industry on certain issues. About 25 years ago, I was on the tax practitioners committee that met in Birmingham once a quarter with the district director of the IRS, and we talked about issues with the IRS. And usually when the IRS is after you, it's a civil matter, very rarely criminal. Now maybe in New York and Miami and some of the big cities where we have real criminal activity, they get after people. But I've only had one tax matter in 35 years that dealt with a person who had committed a tax crime. And he actually didn't call me to help him with the tax crime part of it because he was already in jail when I went to see him. But the IRS was after his assets. They were after him civilly, and so I ended up helping him civilly. Also, there's the compliance measurement audit. That's where they will just randomly pick tax returns, and they will do a complete audit. They come in there and say, I want to see the deductions for everything you've taken. And what they're trying to do is not get after these individuals so much as get statistical information so that they can run the statistics nationwide and better understand what's going on with the tax laws and focus on what they've got to do to improve compliance in the tax area. If you get one of those, it's just bad luck. You gotta substantiate everything. Most audits are handled now out of the service centers. You get a letter, you correspond, you may be cleared up with correspondence, you might talk to somebody on the phone. When we have the agents actually locally handling an audit, they're called office audits or field audits. The office audits where they, usually a business, they will just call you and say, we're conducting an audit, we would like to see this and this and this. They'll ask for perhaps automobile expense substantiation, might ask you for depreciation substantiation, a couple of specific items. And if you supply that material and they're satisfied, it's fine. If you don't supply sufficient material, then you're going to end up with some kind of proposed adjustment. The field audits are a little bit more involved. We have the agents coming into businesses and saying, I'm going to come over there, I'm going to sit down, I'm going to start asking for records and start asking for information. And they come in and sit down and they'll ask you for all of your invoices, and then they'll ask you for your bank records, and they'll actually conduct an audit like an accountant that was auditing the firm. And you can ask, and I often do this, that the agent not come into the business, but instead maybe come to my office and we'll supply the records over there. There's a couple of good reasons for that. Number one, it's not real conducive to your employees feeling good about the business and your customers feeling good if they come in and the IRS is auditing you. And the second thing is, if the records are in my office and they're asking for things, they may ask for something that I don't have, and I can say, well, I'll get it for you, and then we can go back and think about what I'm not saying we wouldn't provide what they're asking for, but the point is, if they're in the office and they ask for something, you can't say, well, I don't have it. I mean, if they're in your offices, you got it somewhere and you got to provide it. Anyway, so if you have an audit, you generally would want to have a tax professional assist you with the audit. Most often, accountants or tax attorneys do that. Also, sometimes the enrolled agents, excuse me, are people who have done training and been qualified with the IRS to handle tax matters. But in order for somebody to help you with a tax matter, either on the audit side or on the collection side, you got to sign a power of attorney, a Form 2848 that says I'm authorized to have the information that you have on the taxpayer, and I'm authorized to talk on the taxpayer's behalf. Most taxpayers that hire me, they don't want to talk to the IRS. And I usually don't have them talk to the IRS. Sometimes they'll say, well, do you want me there at that meeting? And I'll usually say, well, you can come if you want, but I'd just soon you weren't there, because it's almost the same thing as I said with the records. That is, if the IRS asks me something, if the taxpayer is there, he can't say I don't know, or she can't say I don't know, because they do know one way or the other. I can say I don't know, but I'll check with my client and get back, and we go back and we talk about it, and and plus the taxpayer may say something that's not responsive to a question and raise an issue that the agent wasn't even thinking about. So we don't want to educate the agent sitting right there and have the agent looking into matters that he or she might not have been inclined to look at to start with. Okay, the audit process. You get an audit notice. They will either ask you, like I said earlier, about some specific items, or and they may just ask a question. But more often, they'll ask you for substantiating materials for deductions that you've taken. And it's your burden to come up with the substantiating materials. So sometimes we have to go back to the bank and reconstruct records. Hopefully you have your records. I would urge everybody to keep their records at least 6 years, 6 or 7 years. Generally speaking, the IRS can't go back more than 3 years unless there's been a 25% omission from income, and then they can go back 6 years. Now, if you don't file a return, the year's open forever if you didn't file, or if you committed fraud. If the IRS came in and said, we think your omission was fraudulent and they can prove it, then it's an open statute. So if you don't file, they can literally go back 20 years. If you commit a fraud, then they can, again, go back 20 years. But I know we have nobody in here who's fraudulent, and I know everybody in here files their tax returns. So the rule is 3 years, generally speaking, and 6 years in the case where you have at least a 25% omission from income. All right, you respond, you substantiate. Let's say you can work it out, or let's say you don't work it out and they come in with proposed adjustments. You get a final audit report, and when you get that report, you have the right to go to the agent's supervisor and discuss it with the supervisor and try to convince the supervisor that there should be some changes to the report. I will tell you that generally speaking, the supervisor's already seen the report and is already in agreement with it. So your recourse at that point is to file what's called a 30-day letter. You get a 30-day letter. You get to file an appeal within the IRS. They have an appeals office for Huntsville that's in Birmingham. If you're dealing with somebody locally, or if you're dealing with Memphis at the audit level, the appeal goes to Birmingham. And even though these people work for the IRS, they are charged with being independent and not really an advocate. They're supposed to look at this thing kind of the way the court would look at it. And I have had appeal officers on many occasions adjust exam numbers, and we reach an agreement, and it's over with. They don't roll over. I don't mean to imply they roll over. They're going to apply the law, and if you're wrong, then you're wrong. The local agents and the agents out of the service centers sometimes aren't right, and the appeals officers tend to be better educated and more experienced, and so you sometimes get some relief at the appellate level. If you do that and then you don't get relief, you get another final letter. It's called a 90-day letter, and that letter basically says that you can go to the tax court. You got 90 days to file that appeal, and even though the tax court meets in Washington, D.C., they do. Each of the tax court judges have a circuit that they run in the United States, and so a couple times of the year they will come on their circuit, and you can check the box on your petition that you want to have the court held in Birmingham in our case. All the Alabama cases are, maybe Mobile too, but for here in Huntsville, Birmingham. So I've got one pending right now, and we've checked Birmingham, and so we're going to get a hearing date, I would guess probably 4 or 5 months from now, maybe 6 months from now, and then we go to Birmingham and argue our case before the tax court judge. Now, in this particular case, I probably won't be going to court because I have these from time to time. Somebody will come into me, and they come in at the last minute. They come in on the 79th day of the 90-day letter period. In other words, I got 11 days to file an appeal with the tax court, and I got no recourse with the IRS. Nobody at the IRS is going to talk to me anymore. And so, and the only thing that they hadn't done is they hadn't provided all the substantiation for their deductions. It usually happens when they're ignoring the IRS, and then when the IRS finally comes in and smacks them upside the head, they go out and try to find some substantiating deductions. So I filed the appeal with the tax court, and what the tax court generally does, these judges, they're federal judges. They're just like Judge Linwood Smith down here at the federal courthouse. They're important people. Their time's important, and they got a heavy docket, and they don't want to be sitting up there while I pull out receipts and say, well, see, here's where he entertained his client $42 for lunch. You know, they don't have time for that. So what they do informally, and it works real well in these cases, they kick it back to the appeals office, and it gets assigned to an appellate officer, and we try to work out the numbers. We give our substantiation, the appellate officer will accept it or deny it. Usually if they deny it, there's good reason for it. And hopefully what we do is we reach an agreement, and then we, being me and the attorney in Birmingham, the IRS lawyers that are handling the case, reach an agreement on the numbers, and then we file a pleading with the court that just says we've reached agreement, and the court just signs off on it, so we don't actually go to court. Once in a while we go to court. The other recourse you have in the court system is if you don't go to tax court and you still want to go to court on it, you've got the option to pay the liability, and then you got actually another bite at the IRS, because when you pay the liability, you can file a claim for a refund within 2 years. And if the claim is denied, then you can go to the federal district court, local federal district court, or else the Court of Claims in Washington, D.C. But there's a couple of reasons that most people that want to go to court go with the tax court. One is the tax court judges, that's all they do, tax law. You go up here to the district judge and get one of these, or Linwood Smith or another district judge, they handle all kinds of cases, and so tax is just one of the many things they handle. The other thing is, tax courts, you don't have to pay the liability before you go make your arguments. District courts, you do. And, especially if you don't have the money to pay it, that option can be gone. But even if you have the money to pay it, not too many people want to go that route. And I neglected to mention, if you don't prevail in the tax court, you can appeal to the Circuit Court of Appeals, and if you don't win there, you can go to the United States Supreme Court. Very few tax cases make it to the United States Supreme Court, but they do on occasion. All right, I got a little note here about criminal. Like I said, I've only seen one here in Huntsville, and generally speaking, I think they're usually referred by civil. That is that the IRS agents that are handling collections see the abuse, they'll turn it over to the criminal division. I did have one a couple of years ago that probably could have easily been a criminal matter, and the agent that came up from Birmingham to help the local agent on it looked me square in the eye, and I've known him for a long time, and he said, because they were just doing this thing civilly, and he said, you know how lucky your client is? He was basically saying to me they weren't going to refer it, and I said, yeah, I understand. And so, you know, you don't see criminal here. You see criminal in the big cities because a lot of times the tax issues will be tied up with drugs and prostitution and stuff like that. So it's just part of the package. Collections, I actually work in the collections area personally a lot more than I do in the exam area. You know, when somebody's been examined, a lot of times they'll go to their accountant, which makes sense. Their accountant prepared the return. The accountant's familiar with the deductions, and so they go to their accountant. But I find that most accountants don't like dealing with the IRS on the collection side, so I do get some referrals from accountants. What happens on the collection side is once the tax liability is final, that is that the period of time for filing in the court has expired, or else you've gone to court and you haven't prevailed, then it gets turned over to the collection folks, and that, generally speaking, is handled locally, but not always. Sometimes you get a lot of collection letters from the service centers, and there's a lot of service centers. You got them in Atlanta and Memphis and Huntsville, New York, and Ogden, Utah. They're spread all over the place. And I used to get these notices from all over the place, but in the last couple of years, they seem to be mostly coming here from Memphis. So you get a notice from Memphis. Maybe you can work it out over the phone. They've gotten to where they'll take your financial information and try to reach an agreement with you over the phone as far as an installment agreement, because you can do an installment agreement, or even an offer in compromise. But a lot of times those things come locally, especially the offers in compromise. So let me tell you what your options are when you have collections. You've got the option of paying in full, which is what the IRS prefers. I had an IRS group manager here in Huntsville, a lady named Eleanor Allen. She's retired now, but I think she helps taxpayers now. But I sat in her office one time, and we were talking about whether my taxpayer had the money to pay, and she just right in the middle of our conversation, she said, "The IRS is a reluctant creditor." And you know, it's always stuck with me. They don't want to be owed money, they want to be paid. So if you've got the ability to pay, they'll require you pay, and they won't work out any payment arrangement with you or any compromise. Now, how do they know if you have the ability to pay? In order to talk to the IRS about any collection methods that are available, you got to fill out a financial statement. If you have a business, you fill out a separate one for the business, and if you don't have a business, you fill out one for yourself individually. You list your assets, you list your liabilities, and the real important page is the fourth page of that form, where you list your income and your expenses. Now, what the agents are required to do is go through that listing of income and listing of expenses, and they're looking at the expense side mostly, and they're required to allow you certain expenses to meet your living needs, and they're actually region specific. Here in the South, we got certain numbers for housing and food, and they got different numbers up in New York. And I learned a couple of years ago that if you're a U.S. citizen living in Canada, they got real high numbers. Apparently the cost of living in Canada is significantly higher than it is in the States. And so they allow you to cash flow enough money to meet those basic living expenses, but if your income minus those basic living numbers leave a net amount, then what they want to do is talk to you about paying that amount over an installment period, generally 60 months. Or if you want to make a offer in compromise, they want your offer in compromise number to exceed 60 times that number, okay? And so, you know, sometimes you get in the, you have a little give and take on some of the expense items. Unfortunately, they won't allow, if you've got children in college, you're paying their college expense, it's not allowed expense. It's not allowed, that's all. Because there's no support obligation in Alabama that requires you to pay the college expenses of your children. So, you know, of course, if somebody's in there talking to me, they're going like, you know, it's costing me $3,000 a month for these two kids in college, and it's too bad. They don't take that into account. You know, they'll put you in bankruptcy if they have to, and they do sometimes. Sometimes I talk to the agent. I say, you know, if we can't work this out, they're going to have to bankrupt. And they go like, okay, that gets the file out of my office. I mean, I've had them say that, you know, because it's just not much of a threat to say they're going to file bankruptcy. You know, the IRS has its rules. It has very strict rules about what they can and can't do. And I can look at somebody's financial statement and almost tell them what the IRS is going to require that they do. Okay, so you got offering compromise, you got installment, pay in full. Sometimes they'll look at that financial statement and they'll deem you to be currently uncollectible. So they'll tell you, we're going to drop collection efforts. I'll say usually they'll revisit it in a couple of years. Sometimes they never come back. You know, they'll tell you, well, we're going to look at it in a couple of years, but I've had them go 10 years and never come back. There's a 10-year collection statute. That's why I say 10 years. Once you have assessed liability, the IRS has 10 years to collect it. And even if you're making installment payments, that doesn't defer the 10-year period. What does defer the 10-year period is if you make an installment proposal while they're considering the proposal, then that delays the 10 years. So if it takes them 5 months to consider the proposal, then 5 months gets added onto the back of your 10-year period for them to collect from you. If you have a offering compromise being considered, if that takes 6 or 7 months, that gets added onto the back of the 10. If you go into bankruptcy court and don't ultimately come out of the bankruptcy, you know, in other words, let's say you file a 7, but at some point, because it's harder to be bankrupt now than it used to be, they decide you don't qualify, so 4 months later you come out, well, that 4 months gets tacked onto the back of it. If you're in a Chapter 13 bankruptcies where you're making payments to your creditors, and that lasts 3 years, that gets tacked onto the back of it. If you've ever had a tax lien filed against you, or if you ever have a tax lien filed against you, or if you know anybody that has a tax lien filed against you, you can look at the last column on that, not the column with the taxes, but the last column that has dates on it on the right, and that will be the last day they can collect. That's the end of the 10-year period, unless there's been an extension. All right, if it's been extended for the period of time that you had an offering compromise or an installment proposal being considered, then it could go past that date. Now the tax lien expires on that date, but the IRS is allowed, and this goes for the state too, state of Alabama tax liens, they're allowed to file another 10-year lien period. But the second 10-year period that they that they file will expire at the end of the extension period. And in other words, even though it's of record and it shows that it's another 10 years, which is 20 years from the original assessment, if the period only got extended 4 or 5 months, you can contact the IRS and say, look, your statute period has expired, you need to release this lien, and they will file a release of the lien. Now, let me mention something real quick, since Alan jammed me up on time. If you have a tax lien filed and you own real estate, then of course the real estate can't be sold without dealing with that tax lien. That tax lien is a powerful tool for the IRS and the State Revenue Department. But if you need to sell the house, then if there's enough equity in the house so that the IRS is going to get paid in full, it's real easy to get it released. You call the IRS office, you talk to a collection agency agent, you say, Craig Hardwick, somebody I talked to about this today, I said, Craig, give me a payoff on this house. They're selling it, and there's going to be enough money to pay you in full. So he says, well, I can do one of two things. I can write you a letter that says if you will give us this amount of money within this period of time, we'll give you a release, or I can show up down there and give you a release right on the spot if you will get the funds to me in guaranteed funds. That would be a cashier's check or cash or whatever. And so they're real accommodating because they're going to get paid money. If you don't have enough money to pay the IRS in full, then you've got to go through the lien clerk in New Orleans, Louisiana. A lady named Darla Boyd, been doing it forever, good to work with, but you got to get an appraisal on the house to prove that what you're getting paid is full fair market value. They give you a qualified letter back to the closing agent that basically says, as long as the person selling the house doesn't put any money in his or her pocket, and we get all of the net equity and it sells for this dollar amount, then we agree that we'll release our tax lien. And so they will do that, and the reason they do that is because if they didn't do that, you could never sell your house. Same thing on a refinance. If you can get a lower interest rate, it's going to improve your financial position. Well, if it improves your financial position, it's going to improve your ability to pay the IRS. So you do the same thing. You go to the lien clerk, you say, look, I owe $180 on the house, we're refinancing it. They'll even let you gross the refinance loan up by the loan closing costs. as long as you're not putting money in your pocket and you're getting a better interest rate. And they will allow that new mortgage to attach. They'll subrogate their mortgage to the new mortgage, the tax lien to the new mortgage to allow the new mortgage to take effect. So, you know, they're not terrible to deal with, but the IRS is the State Revenue Department's a little rougher on these tax liens. They don't have the same rules as the IRS, and I'd say they're generally speaking not quite as taxpayer friendly. I don't think it's that the people are bad. It's just that they don't have the oversight that the IRS has at the congressional level, and I think as a result of the IRS and the unique position it has with us and with Congress and so forth, that there's just way more protections for the IRS efforts than there are for the State Revenue Department. State's a little tougher to deal with. Okay, now if you ignore the IRS when they decide you owe money, you decide you don't want to work out one of these options with them, that is installment payment, offering compromise, then you will start to get warnings about levy. You'll get the first letter you get from the IRS is almost a love letter. Dear Mike, you owe us some money. Could you please pay it? I think they say please. The second one says, hey, we sent you a letter last month and we haven't heard from you. And the third one says, you know, if we don't hear from you, we're going to have to levy. And then the fourth one comes certified mail, and you got about 30 days or else they're going to come in and seize your bank accounts. They're going to levy on your employer. Your employer gets a levy, then some of your money comes out of your paycheck directly to them. They'll levy against your Social Security payments if you're getting Social Security. If you're in business and they know who your vendors are that owe you money, they'll levy your clients if they know who they are. I had a doctor in there, I don't know, 20 years ago, and she was doing most of her work with Medicaid, Medicare, and they knew it. They levied Medicaid and Medicare. And, you know, it's tough when you're most of your money's coming from Medicaid and Medicare and you're seeing patients and the money's not making it to you. It gets tough. So when that happens, you can, as soon as you get that levy, whoever gets levied, as soon as they get the levy, they can't give you another penny. You got 30 days to do something. Doesn't mean you're going to get the money. IRS doesn't get it. You got 30 days to do something. What you can do is file a request for a collection due process hearing. It's kind of a last-ditch effort thing you do, and basically what you're saying in that due process hearing request is, look, it should never gotten this bad. Let's go back and talk about that installment payment or that offering compromise, and then you got kind of a second bite at it. The other thing is you can always file bankruptcy and get relief. The only thing bad about the bankruptcy is if, number one, even if you filed your returns, you can't bankrupt on the taxes for the last 3 years. So if you've got 10 years worth of liability, and I have people that come in with 20 years liability sometimes, but if you have 10 years worth of liability and you filed your returns, the last three can't be bankrupted on, the rest of them can. Now, if you haven't filed your returns and the IRS has assessed liability based on what's been reported to them, you can't bankrupt on any of those right now. And I'll tell you why I say right now in just a second. But if you didn't file the return, the current rule is you can't bankrupt on it. Okay? And the reason I say right now is because there's a real recent bankruptcy court case that challenged that position that basically said, look, if the IRS assessed the liability, what's the difference? It got assessed. If it's been assessed 3 years, who cares who assessed it? So there's a bankruptcy court case that was favorable to the taxpayer that's going up to the appellate courts, and it might give the taxpayer some relief. And so I hope that passes, because it seems inherently unfair to me that if the liability has been assessed 3 years because the IRS had reporting and they assessed it based on that reporting, versus you filed your return and you just didn't pay, I don't know why you can't bankrupt on it. But having said that, even if you have IRS liability that can't be bankrupted on, when I say bankrupt in this case, I'm talking about Chapter 7, where you just say, here's what I got, I'm walking away. You can still go to the bankruptcy court and ask for, in either a Chapter 11 or Chapter 13, for the court to structure all of your liabilities, IRS included, and have it paid over some period of time. I'm not a bankruptcy lawyer, but I think you can stretch it out as much as 72 months, 60, 72 months. You don't know? I think hadn't you done some bankruptcy? long time ago. I think you can do, in a Chapter 13, that's a wage earner reorganization bankruptcy. I think you can stretch it out 72 months. Chapter 11 would be if you were in some kind of business and trying to stretch it out. Okay, let me just mention one thing here, because I'm running out of time. Besides the individual income tax liability, business owners have a propensity to sometimes fail to remit the withholding taxes from their employees. You know, they get in trouble with the IRS, I mean, they get in trouble in business, and they got this money they're supposed to put in the bank for the employees that have been withheld, and they just do the easy thing. They say, oh, I'm going to do it next week. Well, next week never comes. So they get hit with the employment tax liability. There's a couple, it's a trap. If you're in a business and things are getting bad, do not fail to withhold your employment tax liability. Number one, it's not dischargeable in bankruptcy, no matter what, period. You're going to owe it, period. They can go after your personal assets. Normally you can walk away from a business and not be responsible for business liabilities, but you will be responsible for the employment taxes you were supposed to remit for your employees. And the IRS, and I've never known why, but the IRS usually doesn't catch people that quit remitting their monies for 3 or 4 quarters. And by the time they catch them 3 or 4 quarters, the number's gotten big. You don't have to have many employees, 7, 8 employees. You know, in a year you can owe $100,000. And then they show up. Instead of catching you after a quarter and slapping your hand, they wait till you hang yourself and they come in and get you. And they can get anybody that works in the business that has anything to do with withholding the employment taxes, handling employment tax returns, or handling payroll. So sometimes it's the owners, sometimes the officers, and even once in a while it's just an employee who happens to handle those functions. Okay, I'm out of time.